Today, I will provide an overview of some of the primary considerations of foreign owners or investors in businesses based in the United States. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I'm Chief Executive Officer of the law firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University, and I hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. When establishing a foreign owned business in the United States, the first critical step is selecting an appropriate legal structure. The choice of structure, be it a corporation, limited liability company, also referred to as an LLC, partnership, or sole proprietorship, has significant implications for liability, taxation, and regulatory compliance generally. Each of those structures offers distinct advantages and limitations, and the decision should be informed by the specific needs and goals of the business and its owners. For foreign investors, the LLC or limited liability company is often a popular, though not universal, choice due to its flexibility and sometimes advantageous tax treatment. Unlike corporations, LLCs are not usually subject to double taxation, as profits and losses can be passed through to the owner's personal tax returns, which, depending on your individual circumstances, may or may not be desirable. However, the intricacies of state specific regulations governing LLCs require careful navigation. An experienced attorney and CPA can provide invaluable guidance in selecting the most advantageous and sustainable structure and ensuring compliance with all legal requirements. Once the legal structure has been determined, the business must be registered with the appropriate state authorities. This process involves filing formation documents such as articles of incorporation or articles of organization. And additionally, foreign owned businesses must appoint a registered agent in the state of formation who will serve as the official point of contact for service of process in the event of a lawsuit. Compliance does not end with registration. Rather, businesses must consistently adhere to ongoing reporting and compliance obligations, which vary significantly by state and entity type. These may include, among other things, annual reports, franchise taxes, income taxes, and other state specific filings. Failure to comply with these strict requirements can result in significant penalties and jeopardize the legal standing of the business. Engaging an experienced attorney and CPA early in the process can ensure that all compliance obligations are satisfied in a timely and accurate manner. Foreign owned businesses operating in the United States are subject to federal taxation in most cases. The Internal Revenue Service, or IRS, requires these entities to obtain and maintain a federal employer identification number, or EIN, and file annual tax returns. The complexity of U.S. tax law, particularly concerning international transactions, necessitates a thorough understanding of applicable tax treaties and regulations. Moreover, foreign owners must be aware of the potential for double taxation on income earned in the United States and their home country. Tax treaties between the United States and other nations can, in many cases, mitigate, if not eliminate, this risk. But navigating these agreements requires specialized knowledge. An attorney and CPA knowledgeable in this area of law can assist in optimizing tax strategies, ensuring compliance with all tax obligations, and minimizing potential liabilities and legal exposure. Now let's briefly talk about state and local tax considerations. In addition to federal taxes, Foreign-owned businesses must also comply with state and local tax requirements. These obligations can include, for example, income taxes, sales taxes, property taxes, payroll taxes, and others. Each state has its own tax law, and local jurisdictions may impose additional taxes and fees. The complexity of state and local tax regimes often leads to severe misunderstandings and inadvertent non-compliance. For instance, the nexus rules, which determine a business's tax obligations based on its physical and economic presence in a jurisdiction, can be particularly confusing to novices. An attorney and CPA experienced in state and local taxation can provide clarity on these issues, helping businesses navigate the intricate web of state and local tax regulations. Foreign-owned businesses employing workers in the United States must comply with federal and state employment laws. These laws cover a wide spectrum of issues, including wage and hour regulations, workplace safety, paid medical leave, or in some cases, unpaid medical leave, anti-discrimination policies, and employee benefits. Compliance with the Federal Fair Labor Standards Act, also known as the FLSA, and other relevant legislation is essential to avoid costly legal disputes and penalties, including personal liability to the business owners. Moreover, understanding the many nuances of employment law is critical when hiring foreign nationals. The process involves navigating complex visa and work authorization requirements, which can vary significantly depending on the employee's country of origin and the nature and timing of their employment. An attorney and CPA can provide proper guidance on these matters, helping to ensure compliance with all relevant employment and labor laws. Let's briefly talk about intellectual property. Protecting intellectual property is a crucial consideration for foreign-owned businesses operating in the United States. Intellectual property assets such as trademarks, patents, and copyrights, as well as trade secrets, are valuable components of a business's sustainable competitive advantage. The U.S. offers robust legal frameworks for IP protection, but the registration and enforcement processes can be quite complex and time-consuming. Foreign business owners must understand the importance of securing intellectual property rights to prevent unauthorized use and infringement. This involves, among other things, filing appropriate applications with the United States Patent and Trademark Office, sometimes called the USPTO, and other relevant agencies. An attorney and CPA can assist in developing a comprehensive competitive IP strategy, ensuring that all assets are adequately and appropriately protected and that the business remains compliant with U.S. intellectual property law. For foreign nationals seeking to establish a business presence in the United States, understanding immigration and visa requirements is essential. The United States offers several visa options for entrepreneurs, including the well-known E-2 Treaty Investor Visa and the L-1 Intra-Company Transfer Visa. Each visa category has specific eligibility criteria and application procedures, which can be complex and time-sensitive. Navigating the tricky U.S. immigration system requires careful planning and attention to detail. Errors or omissions in visa applications can lead to delays or even outright denials, impacting the business's ability to operate effectively. An attorney and CPA can provide expert guidance on selecting the appropriate visa category and ensuring that all immigration requirements are documented and met. Establishing a banking relationship is a critical step for foreign-owned businesses in the United States. U.S. banks have stringent requirements for opening business accounts, particularly for foreign-owned entities. These requirements often include providing detailed and comprehensive documentation, such as formation documents, identification of beneficial owners, and proof of business activity. In addition to banking, foreign-owned businesses must also comply with United States financial regulations, including anti-money laundering and know your customer requirements. These regulations are intended to prevent financial crimes and frauds and ensure the integrity of the financial system. An attorney and CPA can assist in navigating these complex regulations, ensuring that the business meets all necessary compliance standards. In conclusion, the legal landscape for foreign owned businesses in the United States is intricate, textured, and multifaceted. From selecting the appropriate legal structure at the outset to navigating complex and sometimes conflicting tax, employment, and immigration laws. Each step requires careful consideration and expert guidance. Common misconceptions and even inadvertent oversights can lead to significant and sometimes irreversible legal and financial consequences, underscoring further the importance of engaging with experienced professionals. By understanding and addressing the myriad legal requirements, foreign business owners can establish a successful, compliant, and sustainable presence in the coveted U.S. market. Professional advice is not merely beneficial, but absolutely indispensable in navigating the many complexities of U.S. state and federal business law, ensuring that foreign owned businesses thrive and achieve their strategic long term objectives. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.